Welcome to Prediction News Update. My name's Chris Gerlacher. I'm the senior political reporter and industry analyst for Prediction News, and we just got two cases to cover today, but they're both pretty hefty ones. The first one comes out of California. The California Indian tribes are accusing Kalshi of running a criminal enterprise. They brought a RICO case against them. So we're going to talk about that. That is a new legal angle against the prediction market industry. And we've got a new brief in New Jersey. We are going to cover Kalshi's latest brief in the Third Circuit because it is one of the strongest versions they've put forward of their preemption argument. Before we get started, make sure to subscribe to our YouTube channel so you can keep up with all of our investigations into these various legal channels. Before we keep going, make sure to subscribe to our YouTube channel at Prediction News so you can keep up with us as we untangle all of these legal cases. I'm here with Daniel Wallach. Daniel Wallach is a sports betting attorney or appellate lawyer. Dan, how you doing?
Pretty good. Trial attorney too. Trial in appellate courts. Thanks for having me back again. Couple of interesting court filings. I mean, we're in the world right now of legal uncertainty. All of this, the ultimate end game here is to have the courts sort this out and determine what did Congress intend through the Commodity Exchange Act's Dodd-Frank Amendment. Are sports event contracts within the contemplation of what Congress intended? And we're like 10 lawsuits in already. You know, we have the three state cases, Maryland, New Jersey, Nevada. We've got the appeal in the Third Circuit, which is Philadelphia. And then we got those 6 other, I think, loss recovery, statute of Anne lawsuits. And now there's a California case instituted by 3 California tribes. So we're up to 11 lawsuits involving the state of Kalshi.
Yeah, they have stepped on a lot of toes in the gaming industry, and I think the RICO case this is a brand new legal angle. Can you give us an outline of what the exact charge is? Because this is a case this is a law that was used to go after mobsters, go after organized crime, and now the tribes are pointing it at Kalshi.
Yeah, I'm less fascinated by the RICO is getting the headlines. But what makes the California tribes lawsuit maybe legally sustainable are that they're focusing on a different federal law. In contrast to the disputes with Maryland, Nevada, and New Jersey, which have hinged on the clash of state law versus the federal commodities law and whether the federal law preempts state gambling laws, the tribes lawsuit injects a different issue into the case. First of all, this is now for the first time an opponent of Kalshi's is controlling the narrative. In the case with the states, Kalshi struck first, and rather than ask for a declaration that their sports contracts were in fact legal, what they argued instead is for federal preemption, and that to the extent that there's legality at all in question, that's a decision that's entirely and exclusively within the purview of the CFTC, which is the regulator which oversees Kalshi's sports contracts that are traded on a CFTC market. What the tribes have done instead was, instead of invoking state law and walking into that state law versus federal law preemption trap, the tribes are principally relying on a different federal law, the Indian Gaming Regulatory Act. And we've talked about this on the podcast before, that the tribes, one of the tribes, chief grievances about all this is that to the extent that Kalshi is making its sports contracts available throughout the state of California, they're not geofencing around the 109 tribal reservations that are governed by Class 3 gaming compacts, which are federally approved under the Indian Gaming Regulatory Act. So to the extent that Kalshi's sports contracts can be purchased or sold, offered, listed, or traded while within the 4 corners of those 109 separate Indian reservations, to that extent, Kalshi's contracts violated. And that's a different animal than what Kalshi is arguing in its litigations with Maryland, Nevada, and New Jersey, which is that federal law displaces state gambling laws. Well, we don't have a state gambling law really that's at issue here. We now have a federal gambling law, and it's a different kind of lawsuit which really discards or disregards the preemption issue and focuses more on the underlying legality of these contracts.
Right. So as you look through how this case could progress, how do you think Kalshi's argument is going to change? Because it's not going to be just the same version of the preemption argument that they've done in the state cases. They're going to have new merits to have to argue instead.
Well, I think their lead argument is going to be one of standing. Can the tribes, do the Native American tribes themselves have standing to bring litigation to recover damages from those entities which intrude upon tribal exclusivity over gaming? Does that right of action belong to the tribes? Does it belong to the state? Does it belong to a federal agency? I think, I haven't done all the drill down research on this, but quite obviously what stands out is the question of standing, because I know the California tribes were very instrumental in pushing through a special California statute that would enable them to sue California card rooms for violating tribal exclusivity. So if they needed a special statute to be able to sue the card rooms, can they sue Kalshi and other sports prediction platforms that are not covered by that special California statute? What law gives them standing to sue? And I believe, at least as it pertains to activities that take place within the Indian lands, I believe the tribes can bring litigation to enforce their exclusive regulatory oversight over any activities that intrude upon tribal lands. But the question is, outside of tribal lands, do the tribes have standing to enforce California state laws? And do they have standing to enforce anything other than IGRA beyond Indian land? So I think the defenses that Kalshi is going to raise are likely going to be, likely going to be tethered to a standing-based argument, and then there will be some preemption-type arguments, at least with respect to some of the state laws that are implicated by the tribes' lawsuit, because the tribes have asserted a federal RICO claim, which is in part based upon violations not only of IGRA, but violations of California gaming law. So there could be some mixture of standing-based arguments as well as a partial preemption argument. But we're not going to get to those defenses quite yet, because I don't believe that the defendants have been served yet in the lawsuit, because the case has not yet progressed meaningfully, even though the complaint asserts that the tribes will be seeking a preliminary injunction or filing for a motion for a preliminary injunction. And they haven't filed a motion like that yet, which suggests to me that Kalshi has not effectively been served with process, nor has Robinhood. My expectation is that, just like in the Maryland, Nevada, and New Jersey cases, the California tribes case is going to proceed to a motion for preliminary injunction and an immediate hearing. And the relief requested by the tribes will probably be for a court to order Kalshi and Robinhood to stop doing business and accepting any kinds of offers to purchase or sell sports event contracts within Indian territory. And that may not be a big damages case, but can you imagine what it would take to unscramble the egg to force Kalshi and Robinhood to disassociate or to geofence 109 separate Indian reservations throughout the state of California? That's where I think the initial battleground is going to be.
And it's not against only Kalshi and Robinhood either. There are other, they're unnamed in the brief, right? These other, organizations and people and founders that may work with Kalshi and Robinhood as well. I mean, that's part of the RICO case, right? Is going after the entire enterprise.
Yeah, RICO enterprise can consist of anyone who materially assisted the conspiracy or the illegal racketeering enterprise. And that could be some of the individual executives, officers, directors, anyone who directed the affairs of Kalshi and Robinhood. And I think you know who we're talking about, the founders. But I think the Does 1 through 20, which are, sort of the unnamed defendants in the case that are typically named John Doe or Jane Doe, they're numbered 1s through 20. I think those are earmarked principally for the market-making firms like Susquehanna and the other companies that provide liquidity for the event contracts in order to, occur. Because without the existence of the market makers. I don't know that there would be sufficient liquidity throughout California or throughout the U.S. So the market makers may be dragged into this at a later stage through an amendment to the complaint. But at least the early battlegrounds are going to be focused on the viability of these claims against Kalshi and Robinhood, and that's going to be teed up probably within the next few weeks on a motion for a preliminary injunction, this time brought against Kalshi rather than by Kalshi.
Hmm. Yeah, the tables have turned in that case. That'll be interesting to see Kalshi on defense instead of offense in one of these cases.
You know, the implication or the appearance is that Kalshi is winning, and they have prevailed on 2 early stage motions, but you have to remember that they are the architects of the complaint, and they narrowly framed the lawsuit not to focus on whether the contracts were legal, but on the preemptive effect of federal law and having the courts make the determination, not that the contracts are legal, but that it's the CFTC's call exclusively to determine the legality of those contracts. So Kalshi wasn't always going to be in a position to control the narrative in every litigation going forward. I mean, they're playing defense in the 6 statute of Anne cases that are brought in various states throughout the country. They're going to be playing defense in this case against the 3 California tribes, and they're going to be playing defense in future lawsuits. If you recall, the tribes, I think, made some early they gave some early signals that they weren't going to stop at one lawsuit. They were going to be filing a multitude of actions. And I think this is really the first shoe to drop. There will be other actions that may be brought in other states throughout the country. So Kalshi's lawyers are going to be generating significant billable hours going forward between the 11 cases that are now pending, one of which is on appeal, and 2 of which are going to be an emergency motion practice. So that law firm, Milbank, is going to have its hands full. And I think the prediction markets practice area is going to be a very lucrative one for the Milbank law firm. But at some point, the courts are going to decide this issue with some level of finality. But I think we're a year to 2 years away from having any finality on any legal ruling. We're still in the early stages, the early innings. A motion for preliminary injunction decided in 2 early stage states is the equivalent of the ball game being at the top of the 2nd inning. We got a long way to go, and I think the next most important juncture in the case, or the overall controversy, is the Maryland ruling, which we expect within the next week or 2, and then following that, the big event, which is the 3rd Circuit oral argument that's going to take place September 8th in Philadelphia.
Okay, well, let's dive into the 3rd Circuit case, because last week Kalshi filed, its 77-page brief. I thought it was one of the strongest versions of their preemption argument. They walked through, why, really why they believe that Congress intended for, the CFTC to have exclusive jurisdiction over event contracts, and why the states really shouldn't be able to regulate anything traded on a DCM, on a designated contract market. So what did you think? What stood out from the brief for you?
Kalshi's preemption argument is focused on sort of the higher level question of not sports contracts per se, but their exclusive jurisdiction argument is that Congress delegated to the CFTC exclusive jurisdiction to regulate everything that's traded on a CFTC market. That's the broad issue, and to the extent it's traded on a CFTC market, state law is preempted. That's how Kalshi would like to frame the issue, as broadly as possible. I think the courts are going to focus more on the narrow question, or the more precise issue of where congressional intent lie with respect to the question of whether sports contracts fit within the ambit of what Congress intended under Dodd-Frank. Of course, Congress delegated to the CFTC the exclusive jurisdiction to regulate contracts that are traded on their exchanges. No one is questioning that. But that's how Kalshi is describing the preemption issue. I think courts are going to look more narrowly at where sports fit into the equation and where congressional intent boils down to on the question of whether sports contracts were within the contemplation of Congress and were intended by Congress to be traded on CFTC regulated exchanges. That's the narrow question. Kalshi's focusing on a question that's much more broadly presented and much more favorably presented to Kalshi's legal position. Courts are going to look at the question of sports contracts, not whether the CFTC is exclusively regulating everything traded on its marketplace. Mm-hmm. Courts are going to look a little bit more narrowly than how Kalshi has described the issue.
Right. And a court can find that these contracts are gaming. I mean, they have the authority to do that, right?
An Article 3 court, an Article 3 federal judge has every power to determine what the law is and to analyze and interpret federal statutes, federal regulations, federal constitutions, state constitutions. The court is not limited or restrained in how it in how it divines congressional intent. It will use all the tools at its disposal, the language in the statute, the legislative history. It ultimately boils down to what Congress intended, and courts are going to be the sort of the referee or the judges on what congressional intent entails here and how it interlays with sports wagering. That's going to be the court's call, and it's not the prerogative necessarily of the CFTC to make that decision. Courts are going to interpret the statute. The agency does not decide its own exclusive jurisdiction and whether preemption attaches. That's an issue that will be decided by a 3-judge panel in Philadelphia, and ultimately, or at least initially, by federal judges throughout the United States at the district court level. But the filing of Kalshi's brief at least starts the clock on the amicus curiae briefs that are going to be filed in support of Kalshi's legal position. And we're going to, I want to hear some of your comments on the Kalshi brief, which was exceptionally strong, but they obviously focus on the broader question and not necessarily focused only on sports contracts.
Sure. I mean, that brief for me explained why Kalshi didn't, or why Kalshi's lawyers didn't address some of the points that have come up in other states. I mean, Kalshi is so focused on the preemption argument that the CFTC is the only regulatory body that has the authority to limit these contracts. That there are some, they haven't even spent a lot of time on the 2010 Senate colloquy, for example, the conversation between Senator Blanche Lincoln and Dianne Feinstein.
It's an inconvenient fact for them.
Sure. So
they were leaning heavily into it in the congressional control case that was pending in Washington, D.C. throughout 2023 and 2024. They referred to the Lincoln Feinstein colloquy probably more than a dozen times in their federal court filings. So when it suited Kalshi to lean in heavily on that colloquy to argue that the gaming category only entails or encompasses sporting events, they were very bullish on very liberal in their use of Lincoln's legislative colloquy. But in this case, they have distanced themselves significantly from that, I wouldn't call it testimony, but it was a colloquy, a conversation that was part of the congressional record involving Senator Feinstein, Senator Lincoln, and that's legislative history. That, the only evidence of legislative intent directed to sporting events is the negative legislative history that suggested that, at least from the chairwoman of that Senate committee, from her vantage point, these were not the types of contracts that Congress should allow on derivatives markets. So the legislative history does not favor Kalshi's position. So of course, they're not going to mention that colloquy a whole bunch of times in their briefs.
And that is something a federal judge can weigh. They can take that colloquy into consideration. It may not have the force of law, but it is an important part of the legislative history, and a judge would weigh that in their decision.
The judge doesn't have to attach controlling weight to it, but it's certainly part of the mix of information that comprises legislative history. It's part of the congressional record. I mean, you can look at the congressional record surrounding the 2010 enactment of Dodd-Frank is, a fairly lengthy document that has conversations and questions and answers between the different lawmakers. That's part of the legislative history. And that history would be consulted only if the statute was ambiguous or capable of multiple interpretations. And I think it's safe to say Dodd-Frank and the 2010, amendments were not crystal clear about whether sports contracts were within the design of what Congress intended. And I think you have to go to external or extrinsic evidence, such as the legislative history, to aid in the court's fact finding here.
We may come out of all of these legal cases with a more precise federal definition of gaming. We might finally get to narrow that down a little bit. Well, I think those are the big things we needed to hit. Is there anything else we need to know about either of these cases before we wrap up?
Yeah, on Friday, July 31st, 4 days. I don't know when this is going to be released, but it would be interesting to see if the CFTC files an amicus brief on Friday, because Kalshi's argument is that the CFTC has exclusive jurisdiction to regulate these contracts. Everything is directed towards the CFTC is the only body that can make the call here, and Congress intended for the CFTC to have the sole voice on ascertaining whether these kinds of contracts should be allowable. So with Kalshi leaning so heavily on this delegation to the CFTC, it does beg the question of whether the CFTC will weigh in here and take a position, back Kalshi, do something. And while it is not required to file an amicus brief, I think the failure to file an amicus brief on Friday might be conspicuous, might be noticeable. The court could take that into account as part of its decision making, or alternatively, the court can ask for the views of the federal agency. I mean, that's certainly one possibility. But I mean, if you think about all the stakeholders that brought their artillery to the amicus curiae briefs in New Jersey, you have the American Gaming Association, 34 state attorney generals, 100 tribal organizations and their trade associations. You had the cavalry backing up New Jersey here, in the filing of amicus briefs. Who's going to support Kalshi's legal position? I think the obvious answer would have to be the CFTC. So that's what I'm going to be looking for and waiting for this Friday, and that's going to be an important development to see whether the CFTC files an amicus brief and what they have to say about this issue.
Yeah, there's a lot to watch this week, a lot of high drama, even as we wait for the Maryland district opinion.
I'm really focusing on the Third Circuit oral argument now. I plan on, I think I might have to make the trip up to Philadelphia to catch it, because I think that's going to be the most important. Obviously, every successive decision is the most important decision in the case, right, until the one that follows afterwards. Mm-hmm. But we're talking about a federal court of appeals ruling, and that's going to be that's going to have much more influence and weight than any of the lower court decisions. So I think that's one I'm excited about. It might bring me back to my old stomping grounds, because when New Jersey was trying to get legal sports betting and was taking on the federal government and the federal and the professional sports leagues, there were 3 oral arguments, over the course of, I think, about 4 years, held in that same Philadelphia federal courthouse. So looking forward to getting back there to the scene of the crime, and watching, seeing how these issues get argued, and how the court feels about the case initially, because it's probably going to be a very hot bench. And ordinarily in federal court of appeals oral arguments, you have a pretty good idea following the oral argument about which of the two sides is more likely to prevail.
Mm-hmm. Yeah, that'll be fascinating to watch. We're all really looking forward to it over at Prediction News. And that's pretty much everything we've covered. So if you like what you've heard today, subscribe to our YouTube page at Prediction News. Follow our reporting at predictionnews.com. Follow us on X at Prediction News. And, thanks everybody. We'll keep you updated once we hear something new. Dan, thanks for being here again.
My pleasure. Thank you, Chris.